A contract functions as a temporary legal life cycle. Two distinct entities are bound together by an enforceable obligation that snaps securely into place. This bond is designed to be finite. In legal terms, the conclusion of this relationship is known as the discharge of contract. Discharge represents the formal termination of the life cycle. This is the intended conclusion, where the contract executes according to its own terms. In actual performance, both parties fulfill their promises perfectly. One delivers the goods, the other pays the price, and the contract completes its arc. However, the law must also account for commercial friction. This leads to attempted performance, formally known as a tender. A tender occurs when one party arrives prepared to fulfill their duty, but the other party refuses to accept the delivery or service. Under strict legal rules, a refused tender is treated as valid performance by the offering party. Because they attempted to fulfill their part, their specific obligation is discharged. Actual performance resolves the bond as intended. The remaining 5 pathways address the legal friction that arises when that ideal scenario fails. Because parties have the power to forge a contract, they also hold the power to dismantle it. The second pathway is discharge by agreement, where both sides mutually decide to end the bond. Section 62 governs novation, replacing the old agreement entirely. Parties can rewrite core terms or transfer debt to a new person. This differs from alteration. Here, the original parties remain the same, but the specific terms, the data moving between them, are changed. Rescission cancels the contract completely, terminating all legal obligations without creating a replacement. Under Section 63, parties can optionally opt for remission, accepting a significantly lesser performance to settle a debt. Legally, remission is unique because it requires no new consideration to be binding. The simple agreement to accept less is enough to discharge the original, larger obligation. Finally, waiver is a unilateral act. One party intentionally gives up their rights under the contract, permanently freeing the other side. The legal power to construct an agreement carries with it the tools to safely deconstruct it through mutual consent. While the previous pathways were driven by intent, the next 3 dissolve the contract through non-negotiable external forces. Discharge by lapse of time occurs when a party fails to enforce their rights within a statutory deadline. If a debt is not claimed within the required window, the contract becomes time-barred and legally dead. Discharge by operation of law covers scenarios like death, terminating contracts based on personal skill, or insolvency, which legally clears a bankrupt person of previous liabilities. The law also reacts to physical tampering. An unauthorized material alteration to a contract document, changing a price or a date without consent, terminates the agreement. Finally, discharge by impossibility applies when an unforeseen event makes performance physically or legally unattainable, rendering the contract void. The legal system prioritizes commercial reality. It will not enforce a bond that time, legal status, or physics have made impossible to satisfy. We reach the final pathway, discharge by breach. This is the failure or refusal to perform an obligation without a valid legal reason. This timeline shows how failure timing determines legal options. An actual breach occurs here. The promisor fails to deliver on the due date. An anticipatory breach happens earlier, when a party clearly refuses to perform before the due date. In this scenario, the contract only ends prematurely if the aggrieved party chooses to accept the early refusal. If they do not accept the early refusal, the contract remains legally alive until the actual due date, at which point the failure formally becomes an actual breach. When a breach occurs, the primary obligation dies, but it immediately triggers a secondary legal mechanism, the right to claim damages. We move from how a contract breaks to the precise calculation of the consequences under Section 73. The governing compensatory logic of contract damages focuses on restitution. Financial compensation covers real loss, rather than punishing the breaching party. Courts award compensation for natural loss and expected loss, damages predictable when the contract formed. However, courts reject claims for remote or indirect loss. If a loss is too far removed, the breaching party is not required to cover it. This standard changes when a contract pre-writes a fixed financial penalty for a breach, a situation governed by Section 74. In these cases, a court will typically override the fixed penalty amount. Except in specific government contracts, the judge will award only a reasonable compensation based on the actual damage sustained. The court functions as an auditor, calculating the monetary gap caused by the breach and refusing to use damages as a tool for revenge. Money is the most common remedy, but it is not always a sufficient substitute. The injured party has other tools. A suit for rescission officially cancels the contract, releasing the injured party from their own future duties. Under the doctrine of quantum meruit, meaning as much as earned, a party can claim payment for work already completed before the contract became void. Specific performance is a more direct remedy. Here, the court orders the breaching party to execute the exact promise they made. This is reserved for unique cases, such as the sale of a rare asset, where financial compensation cannot accurately measure or replace the loss. Finally, an injunction is a court order that stops a party from performing a specific action that would violate the contract. The Indian Contract Act ensures commercial predictability. When a promise is broken, the law deploys a proportional mechanism to restore reality.